You are watching PR English Shorthand Dictation's YouTube channel.
This is English Shorthand dictation number 415 and the dictation speed is 120 words per minute. Ready? Start. These appeals arise from the judgment dated 17th August 2012 rendered by the Division Bench of High Court of Punjab and Haryana, whereby the intra-court appeals preferred by the appellants herein were dismissed and the judgment dated 11th August 2011 passed by the learned single judge of the High Court was upheld. Learned single judge rejected the civil writ petitions preferred by the appellants for grant of benefits under the Proficiency Step Up Scheme 1988 and ACP Scheme 1998 by accounting for their entire service period, including that in the work charged establishment. Learned Senior Counsel, appearing on behalf of the appellants, vehemently and fervently contended that the government of Punjab has, on its own volition, extended the very same benefits of proficiency step up to other employees situated at par with the appellants, and thus the differential treatment meted out to the appellants tantamount to hostile and subjective discrimination, which is violative of Article 14 of the Constitution of India. In this regard, Learned Senior Counsel drew the attention of this court to the policy circular dated 13th March 1996 issued by the Department of Irrigation and Power, Government of Punjab, whereby it was decided that the government policy contained in the letter dated 7th May 1993 would be relaxed and the services of the work charged staff of Ranjit Sagar Dam would be regularized. He submitted that clause bracket small a of the said policy circular clearly provided that the past services rendered by the employees on work charged or daily basis will be treated as qualifying service for pensionary and all other benefits. Learned Senior Counsel further referred to various communications and circulars, more specifically to the circular dated 12th April 2005 issued by the Chief Engineer Irrigation Department, Punjab. Learned Senior Counsel for the appellants thus submitted that the appellants herein are entitled to reliefs sought for in these appeals by reversing or modifying the judgment rendered by the learned single judge of the High Court as upheld by the learned division bench. During the course of submissions, learned senior counsel for the appellants had restricted the claims of the appellants to the benefits under the Proficiency Step Up Scheme 1988. Per contra, learned AAG, representing the state, vehemently contested the submissions advanced by the counsel for the appellants and urged that the benefits under the Proficiency Step Up Scheme 1988 to employees situated at par with the appellants herein were extended only in the cases where such employees were granted the said relief in compliance of the orders passed by the courts in judicial proceedings. Nonetheless, Sri Irfan was not in a position to dispute the fact that the circular dated 12th April 2005, issued by the Chief Engineer Irrigation Department, Punjab, clearly provides for the grant of proficiency step up to employees of different categories who were left out after the various judgments of the courts without any court orders being in force qua such employees. We have given our thoughtful consideration to the submissions advanced at the bar and have perused the impugned judgments. With the assistance of learned counsel for the parties, we have thoroughly examined the material available on record. The primary issue that arises for consideration before this court is whether the service rendered by the appellants herein as work charged employees prior to regularization is to be accounted towards the grant of benefits under Proficiency Step Up Scheme 1988 in view of the fact that other similarly situated employees have already been granted the same benefit. The fact that the appellants herein were regularized in service and the period spent by them in the work charged establishment was ordered to be counted for qualifying service for pensionary and all other consequential benefits is not in dispute, as the same is clearly discernible from the policy circular dated 13th March 1996 referred to Supra. However, a significant bulk of litigation in the form of writ petitions had ensued on behalf of the employees engaged in the work charged establishment who claimed that the services rendered by them as work charged employee should be counted for the grant of benefits under the Proficiency Step Up Scheme 1988 and the ACP Scheme 1998, and their claims were accepted by the High Court of Punjab and Haryana but were restricted to only the Proficiency Step Up Scheme 1988. A perusal of the impugned judgments would reveal that the division bench treated the Proficiency Step Up Scheme 1988 and the ACP Scheme 1998 to be at par. On examining the judgments rendered by the learned single judge and the division bench of the High Court, we find that the precise connotations of the government circular dated 1st December 1988, which had introduced the Proficiency Step Up Scheme, were not considered in an appropriate manner. The fundamental distinction in the present case is that the policy circular whereby the services of the appellants were regularized gave a clear mandate that the services of the work charged employees would be regularized and the past services of such employees would be treated as qualifying service for pensionary and all other consequential benefits. The High Court seems to have overlapped the ACP Scheme 1998 and the Proficiency Step Up Scheme 1988 for denying relief to the appellants, which is not justifiable by any stretch of imagination. A writ petition filed by the state against the said order of the tribunal was dismissed by the division bench of the High Court, and the SLP preferred challenging the same has been rejected by this court wide order dated 19th October 2010. Thereafter, the Irrigation Department of the Government of Punjab wide order dated 9th November 2010 unconditionally decided to implement the decision of the tribunal. In view of discussion made above and in the peculiar facts and circumstances of the instant case, we feel that the differential treatment could not have been meted out to the appellants herein, who formed a part of the same establishment and were similarly situated to the employees who were granted the benefits under the Proficiency Step Up Scheme 1988. Resultantly, we hereby direct that the appellants shall be entitled to have their services in the work charged establishment counted as qualifying service for proficiency step up in accordance with the proficiency step up scheme issued wide government circular dated 1st December 1988. The monetary benefits flowing from the above direction shall be paid to the appellants within a period of 6 months from today.